Hi, folks. It's time for This Week in Law. I'm Denise Howell, and Mike Keyes and Franklin Graves are joining me this week. We're going to discuss YouTube bringing a scaled-down version of Content ID to the masses, 415 Congress critters passing a Music Modernization Act. That's not Lindsay Lohan you're seeing in Grand Theft Auto. Creepy devices for 500, Alex, and yodeling with Mason Ramsey. This and more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keyes, and Matt Curtis. Episode 422, recorded May 11th, 2018. 2 weeks in Fortnite. Hi, folks. It's Denise Howell, and you're joining us for This Week in Law. It's a very happy day here at This Week in Law. We have two very happy birthdays in the house. Victor is having his birthday today. Congratulations, Victor. Glad to have you on the board. Thanks for being with us.
No problem.
And our guest, our former intern, Franklin Graves, had his birthday yesterday. Happy birthday, Franklin.
Hey, Denise. Thanks for having me, and happy birthday to me. I'm the big 3-0. So as of yesterday, I'm now 30. I'm entering into the next decade of my life. So
I was going to ask you if it was a milestone birthday, and it is.
Yes, it's the big 30. Luckily, I had a great celebration yesterday and then also on Sunday over the weekend. So it was a lot of fun.
That's great fun. Also here is Mike Keyes, who is a partner at Dorsey & Whitney in Seattle, Washington, and my co-host. Hi, Mike.
Hello, Denise. Great to be with you, and great to be with you, Franklin. Happy belated birthday.
Thank you.
So, Franklin, we need to catch up a bit. Let people know. You are one of those wonderful people who actually joins us even when you're not in front of the camera on the show. You love to jump in IRC. I see you in there frequently. So thank you so much for joining us for that. And thanks to everyone who's there with us right now as we record live. But, I'm sure folks in IRC and folks who are fans of the show want to know what's going on with you these days, because you've had a bit of a career shift.
Right, that's correct. So now I work for a technology company called Eventbrite. It is based out of San Francisco. So Eventbrite, if you're not familiar with it, it is a ticketing and registration platform with the mission to bring the world together through live experiences. So I am very excited to be a part of a larger legal team now. So previously when I've been on the show, I was working for a classical music company. And I really, really enjoyed the experience that I had there, gained a lot of industry knowledge in terms of the entertainment industry, but now it's kind of progressed further, and I'm mainly excited to be a part of a larger legal team, like I said. So I'm not the only attorney. I've been lucky enough to have a phenomenal first month with Eventbrite, and it's just been a whirlwind experience, and I really am enjoying it. So yeah.
And where are they headquartered?
They're based out of San Francisco, but I'm here in Nashville still, so it's a Nashville office that they have. They do have offices all over the world. You can actually go to eventbrite.com/contact, and there you can see a drop down of all the different office locations and pictures of everywhere that the company actually has like an office or a physical space. But yeah, so we most recently have a company that we bought called Ticketea. So that's a great partnership to have them on board now. And it's just continually growing, and I'm excited to be a part of the team.
We're super excited for you. That's just great news. So cool that you get to work for a tech company. I know that's probably been in your sights for a while, and that you get to stay in Nashville where you're happy with your family. It's just total win-win. That's just fantastic. How are the kids, and how is your pug?
So I have one 7-month-old, and I have a pug. So I guess I have 2 kids. My wife and I are very happy and fortunate to have a 7-month-old at this point. But she's wonderful, and I'm enjoying being a dad.
Very, very good. Wonderful to have you back on the show. Let's get right into it. For your birthday, you gave us some great gifts, which were some wonderful topics to cover today. So let's get into them. We'll start with copyright. So there's an exciting development if you're a YouTube creator. News has broken that creators on YouTube may have their first bit of recourse from the company itself to help them in the situation where after they upload a video, others immediately appropriate their video and upload it themselves and try and pass it off as their own. Tell us what's going on there, Franklin.
Right. So I think that longtime listeners or frequent listeners of the show, or anybody that follows the tech industry in general, is probably familiar with the content ID system that YouTube has and has had for quite a while on their platform. But back in April, they announced and posted some videos showing what is called a new tool called Copyright Match. Which is currently a beta feature, so it's limited to just a few creators that have been selected by YouTube to try it out and provide feedback. But they're currently testing it, and once a video is uploaded, YouTube creators that are enrolled in the program, they have Copyright Match automatically searching for exact or similar videos that pop up on YouTube later. So the system prioritizes what I'm quoting as ownership, original ownership, based on the upload date of the video. So if This Week in Law, for instance, cuts this segment down and uploads it to YouTube, then TWiT would be the first one to upload the video, and they would have established priority in the system. So TWiT then will see a dashboard in the Copyright Match system that displays similar matches. And from that, it shows also a percentage of the match. And you can kind of see it in that thumbnail on this article from TWiL. And once that's seen, then it's up to the creator to decide what to do. And so YouTube, in this case, has given creators 3 options. The first option is to do nothing. The second option is to get in contact with the creator that has uploaded the content or re-uploaded the content. And then the third option is to ask YouTube to take down the video. So if a request, this is basically all information that we can gather so far from the videos that have been posted. I actually haven't myself had any personal experience with it, but from what we can tell, if a request is sent to YouTube to remove a video, then they will review the request. I'm unsure if it is actually a person that's reviewing it or if it is just a different type of review, maybe an algorithmic review of some kind. But it's interesting at this point because YouTube has asked the original uploader to verify that the video doesn't qualify for fair use, which is similar to what we would see under the Content ID system and any other type of DMCA takedown notice. The new request of some kind to verify that fair use has been considered. So it does seem from the information. Sorry, go ahead.
That's straight out of a Ninth Circuit decision that we've discussed here on the show before.
Yes, exactly. So that's kind of where that's stemming from. And actually, I'll give a shout out to GitHub. They have incorporated that same type of language into all their wonderful information they have on their website about the DMCA takedowns. They've incorporated that request that the person filing and submitting the takedown request to them has considered fair use in their analysis of whether this video should actually be taken down. So other information at that point that YouTube might request is some type of real name. So a lot of times YouTubers don't use their real name or have it associated yet with their YouTube channel. And so they might ask for additional information, even a signature sometimes for the notification for the takedown request. And then from there, the dashboard will then update if the person that has uploaded their video following this original upload, the new creator, it will notify whether it was then counter noticed. So from that point, then it proceeds off the platform and through the standard litigation route or outside of the system discussion and hopefully maybe reaching an amicable solution at that point. So any questions about that? Any other comments before we kind of move on? I can go into more of the content ID and we can talk about some of the differences.
Yeah, I think it's fascinating on so many levels. Let me start with one. First, I think it's really fascinating that we've moved to a point, or YouTube has moved to a point in its evolution where content ID is now something the masses want, need, and welcome for their own creations, as opposed to this being something that's being developed and implemented just to make the music industry and the television and movie industries happy. So I think that's just an interesting thing to note and think about. I also am scratching my head as to why YouTube decided that this copyright match should be so much different from Content ID. Why it's not giving YouTube creators the ability to protect against having portions of their work copied, like it does for those larger industries I just mentioned. Why it's not giving YouTube creators the ability to monetize if it want, one of those options. Take it down. No, don't take it down. Just funnel me the ad dollars would be a nice choice for them too. So it's interesting that they've made these value judgments and decided this product we're going to offer our creators is going to look a lot different than the thing that we've given the content industry. I think that fair use point is amazingly fascinating. That now not only are the legal departments of the various industries I mentioned required to do sort of an ad hoc legal analysis of whether a video being taken down is fair use. And as a practical matter, of course, it's not the legal department, it's whoever is managing their YouTube presence. But now all of the non-lawyer users of YouTube who happen to have their own YouTube channels are also being put in that interesting situation where they're being made to understand fair use laws and do an assessment before they decide to pull the trigger and ask to take something down. Mike, anything else this triggers in your mind?
Yeah, so I agree with you. It's a really interesting development here, and it wasn't clear to me, and Franklin, maybe it's clear to you, but it seems like this is kind of creating its own little private DMCA enforcement regime. And under the DMCA, if you send a notice under Section 512, as you noted, Franklin, you have to essentially certify that your claim is founded. And of course, under the Ninth Circuit Dancing Baby case, you now have to have given some analysis to the issue of fair use. I'm curious. It sounds like you have to do the same thing using this new tool that Google's going to roll out. But what if you don't? You wouldn't necessarily be subject to DMCA liability, it doesn't seem to me, because this isn't a DMCA. You're not really operating under that regime. This is kind of a private Google DMCA notice and takedown regime. Is that right?
Right, that's essentially correct. And it kind of mirrors what is currently available with the Content ID system, where it is, as you alluded to, a self-imposed dispute system that YouTube has developed for their platform. So essentially, yes, this is just an option. A creator, a YouTube video, a YouTube channel owner, sorry about that, a YouTube channel owner has the option to go outside of the YouTube platform and system and just go straight to submitting a DMCA notice to YouTube, and then from there also getting in touch with the uploader and trying to track down their information that way. I think that one of the benefits of doing it through the YouTube system is that you have a better chance of it being handled more quickly and more appropriately. That's just my preference. I think that a lot of content creators and internet creators respect the fact that people utilize the built-in system first, as opposed to, no offense, wasting a lot of legal fees and trying to go the route of involving outside counsel if necessary, and treating it more like an official infringement case at that point. Does that kind of make sense?
Yeah, it does. I'm wondering though, under the DMCA, if a notice has been improperly issued, there is a potential, I guess, safety valve, or I guess a bit of a check and balance. You could bring a claim under Section 512. You could ultimately recover your attorney's fees if you're successful, if a notice was improperly issued in the first instance. But if you're going through the Google private system now, is there recourse for somebody whose video has been taken down? Can they sue pursuant to this new copyright match system that Google's implementing? Do you sue under that particular agreement with Google? How's that work?
So I think the step with copyright match, the step before the video is actually taken down would be this opportunity for that second uploader of the content to submit a counter notice within the system, within the copyright match system. And then at that point, it would be back on the original uploader to then proceed through alternate routes of pursuing a takedown of some
Wow.
Franklin,
does that answer your question? I think I'm understanding it correctly, right?
No, I think so. I mean, I guess the ultimate issue, though, it seems to me, as far as protecting people that have legitimately posted a video online, under Section 512, I know if I've posted a video online and somebody issues an improper takedown notice, I've got a potential Section 512 claim I could bring against that individual for issuing an improper notice.
Right.
But now that you're operating, if people are operating under this kind of private regime that Google's implementing, then it seems like you don't have the Section 512 potential claim against somebody that's improperly issued a takedown notice, rather, excuse me. So I don't know. It sounds like maybe that's maybe uncertain as to how that would work under the copyright match system.
Well,
Right.
I think all we can do is guess about that. And
Yeah.
my guess about that is that YouTube would begin to punish people who they thought were abusing the system. If they were, repeatedly filing requests for takedown as to videos that actually didn't require it or weren't a match. I assume they have some sort of safeguard in place so that you can't just say, "Hey, I got a match here," when you didn't really. Is that true, Franklin? Can you tell?
Right. So from what we can tell, it looks like the match percentage will help them gauge whether they really should be submitting the claim. But at the same time, right, I think that the point that you're talking about in terms of the abuse happening would be the lack of consideration in terms of whether there was some legitimate reason that this video matches and the content was allegedly reposted in some fashion. So whether that's a fair use claim or some other right that the person would be able to have, or defense in terms of being able to have the video uploaded, I think that would be where, if that occurred frequently enough by a particular channel owner, then YouTube would probably flag that as some type of abuse of the copyright match tool, and then from there limit the access to that tool from the person. But again, that's just speculation on my part as to how they would handle that.
I mean, Mike is correct to point out that we've seen countless examples of the DMCA being abused, and people using it for purposes that Congress never intended. So there's no reason to think that wouldn't happen with this kind of a tool as well, and that it doesn't happen with Content ID. So it is interesting to sort of ponder how YouTube and Google and Alphabet deal with that, since they, if you're outside the normal DMCA structure, you don't have that pretty toothy provision that dissuades people from abusing the DMCA, because they're going to be on the hook financially if they do. So very interesting. Thank you for bringing that to our attention. Sorry?
I can just ask Mike one thing. I've been trying to think on what you were just talking about, the distinctions that you were making. I think back to, there was a case, actually, we talked about it last time I was on the show, if I'm not mistaken, about the YouTubers, the H3H3 Productions, and they won a court case based on an alleged claim of copyright infringement through DMCA takedown notice, all that rigmarole there. But I think in that particular lawsuit, I'm quickly looking here, I believe that the built-in DMCA system, I'm going to try to look at that real fast, but in that case, I think the court, it'd be interesting to see whether the court cared that the built-in takedown measures that might have been available and submission for, like, if this had been actually within Content ID. So at the time, Copyright Match didn't exist, but if it did, and the original uploader of this video decided to pursue somebody else that had taken and uploaded their video and chopped it up and added commentary to it, like we saw in this particular case, I wonder there if Copyright Match had been used by the original creator to flag it and say, hey, this is potential infringement, and I believe this is infringement, and from there they issued a takedown using Copyright Match. It'd be interesting to know whether the court would have ruled differently, or whether, are you saying, Mike, whether that would have changed the scope of how that case would have proceeded in litigation because this tool was used at first to provide the notice of copyright infringement?
Yeah, I think so, Franklin, because at least as how I'm understanding it, even though Google is using essentially the terms of the DMCA on Copyright Match, you're not really issuing, and I could be wrong on this, but it seems like you're not actually issuing a formal DMCA notice pursuant to the Copyright Act. You're using this kind of privately developed tool by Google that mirrors the Copyright Act in a number of significant respects.
Okay.
But of course, the Copyright Act is what provides the hook for a potential cause of action against somebody, a serial abuser, or somebody that has just issued a takedown notice without thinking about it. And it'll be interesting, I think, to see how this plays out if there's a similar type of policing or enforcement mechanism that Google implements to combat that issue. I suspect you're exactly right, Denise, that there's going to be some way for Google to monitor whether notices have been provided properly or appropriately, and then Google will be able to take action on its own. So it's an interesting development for sure.
Yeah, as Franklin points out, it's likely to be faster than the other kind of process. And it's likely that nobody but all of us here talking and listening would think about the fact that there's a distinction between what YouTube offers and what is offered under the law. And they look a lot alike and they function a lot alike, but there are actually two avenues you could pursue and that you might want to pursue. And that the faster, more streamlined YouTube option might be more prone to abuse for someone who's not just, out to doing a competitor, but someone, for some sort of ideological reason, you want to come after someone because you don't like the content of what they're posting. That could be problematic too. I wonder how they're going to wrap their arms around policing that.
Yeah, and it does raise the other issue, because under the DMCA, if an online service provider complies with the DMCA, then it is insulated from money damages under the Copyright Act. And so if third parties are no longer using the DMCA, but are using this separate system that Google has created, it seems to me that Google would have a pretty good argument saying, look, we've created this private system. No matter what we do, how we operate this system, we're kind of operating outside of the formal DMCA notice and takedown process. So we would be insulated from money damages regardless. So I don't know. There's a number of questions, but I think it's I applaud the development. It seems like it could be a really worthwhile tool. Always subject to potential abuses, though. But we'll see how that plays out.
Yeah, back to my point about it's interesting that now the whole ecosystem clamors for such a tool because people are starting to have presences that warrant it, or have been, I guess, for some time. Franklin, speaking of YouTube presences, you're the only one of us here on the call that has a YouTube channel that looks anything professional and squared away. If you look up Franklin Graves on YouTube, you'll find him where he does a law school strategy series, or has done. Are you still making new episodes of that, Franklin?
Right. It's currently on hiatus due to obviously a career change and some other life happenings, being my daughter. But yes, it definitely is something I'm looking to continue to pick up again in the future. And I also have moved more in the direction of a new property I've developed called Frankly Legal. I think largely that was generated because of the GTLD.legal. And so Frankly just happened to be available, or I was able to obtain frankly.legal as a URL.
Nice.
And from that, I'm also pursuing a new side project of creating a hub of a hub of legal education for internet creators. And that stems from my involvement over the past 2 years in several Slack channels or Slack workspaces, they're called, where I volunteer and kind of work alongside a lot of other internet creators and discuss all these burgeoning issues when it comes to being an internet creator. Simply as that.
I love it.
Very
A
cool.
project born of a domain name. And a domain name alone. So Franklin, have you ever had one of your videos that you know of that you haven't had a tool that's been able to show you immediately if one of your videos had been immediately copied and re-uploaded by somebody else, but have you had issues like that you're glad this is going to address?
Right. So as of right now, no, that's not happened to me. I guess I'm not internet famous enough to have that happen. Not that I want to either. But with the people that I've worked with, I have seen a couple of different ways that this has happened. So the first and more prominent way in which videos are quote unquote ripped or stolen from the YouTube platform is the first one being if they create just a new domain off of youtube.com. And what we've seen there is YouTube videos being embedded, or even in some cases, the person that's creating the site will go and find the actual URL to the hosted video on Google servers and embed it and somehow put it into a website that is just flooded with other ads. And sometimes they'll utilize SEO techniques to have that site be the first that shows up when people search for either through Google or some other platform, be the first result that shows up. And so therefore it's just redirecting somebody off of the YouTube platform and directly onto this other person's site where they've either embedded the video, or I would assume, and as I've looked into it, is more than likely a violation of YouTube and Google's terms of service, but linking to and actually embedding directly the file from the Google server so that it basically just plays back on this website without even using the YouTube player, increasing the view count, all that kind of stuff. But
yeah,
in that case, they're making money off of the ads that are served alongside the video. And that can be traced. That was just one instance where it can be traced by a YouTube channel, because sometimes they do see that this traffic and these video views are coming from a certain location that they're unable to figure out where it is. So
yeah, what a fascinating, first of all, what a shady practice. And secondly, what a fascinating legal issue that raises, because there are all kinds of cases about deep linking from the early days of the web that invokes, and also the trespass to chattels cases where you're using somebody's computer resources without their authorization. And I think that and overtaxing them. And I think that maybe both those arguments could be made against that practice.
And so the second common method in which, a lot of internet creators are facing is re-uploading of content to another platform. So whether that is And then we've all probably seen it in terms of a Facebook video, or Instagram, or Reddit now has video, where it's basically they slice and dice or re-upload the entire video onto a different platform that may or may not have some type of content recognition system in place, or automatic content recognition system in place, like Content ID.
Right.
And if they did, then if it's just some independent creator, they're not going to have access to that platform anyways to be able to get that recognition happening on the content. So anyway, so that's the second major pain point I would say that a lot of internet creators face, is the swiping of content. So.
Yeah, and I'm glad you brought that up, because obviously the new YouTube system, Content Match, can't help you. If you're seeing your video showing up on Facebook, you're going to have to go and deal with it that way, not through a quick little tool that YouTube has provided. But, as you were saying that, it occurs to me that one reason why Google may have made the distinction between Content ID and Content Match, we're going to match the whole video and not break it down so that we can identify small segments of it, is the proliferation of channels that aggregate other YouTube videos in sort of a commentary way. If you want to see all the funny animal videos from this week or what have you. And so it would be harder to do a takedown that challenged one of those, and those are more likely to be fair use anyway, than it would if something matched your entire video. So
yeah, if I can actually build on that point you just made, that's actually a really good distinction there, because it not only plays into what you just described, which is like the compilation style videos, or where if I upload a video and it becomes viral, or right before it comes viral, I get a call from a GoPro type company that wants to license it and re-upload it to their own channel, which is common. Then what happens outside of that, though, is you have a lot of internet creators and YouTubers that are utilizing the same stock assets. So whether it is stock video footage, stock audio, sound clips, sound effects, background music, all of that would ultimately flood, as you just said, this copyright match system if it did distinguish between an entire video versus just like with a mainstream media property, I would say, or a traditional media property like a SpongeBob SquarePants, for those of you that are familiar with legal history with YouTube, a SpongeBob SquarePants Viacom video in full. The Content ID system will take that and recognize portions of it and cut it out, and even audio and music, clips of music that are in the background. But that's on the Content ID side. But on this copyright match, what we're kind of missing here is the ability to do that. And I think a lot of that stems from the fact that less traditional, more internet independent creators utilize a lot of the same stock assets, which would cause a lot of confusion with the system. And as we saw in the current copyright match dashboard, it shows a percentage match. And I'm sure that would drastically impact the impact that would have.
Right. Well, thank goodness you and Sando created most of our bumpers. So we're not going to be matched up against others using them, except without your and Sand's permission. Let's move on. Or Twit's permission. I guess you guys were work for hire on those, maybe. I don't know. We could talk about that another day. Let's move on and talk about the Music Modernization Act and what's going on there. Mike, one of your colleagues at the TMCA has a post about it. It seems like the point of this proposed legislation is to enable folks to stream music more readily than they can now without having to go to individual artists and get permission to include them in their streaming service. And it's going to work just like, I know it's not a perfect analogy, but like radio works, where you would have a blanket license, and based on the number of plays, you would owe royalties to a centralized agency that would then pay out to the artists. But there's some controversy about the royalties that would be available under this new act for pre-1972 sound recordings that aren't available now. Do you want to speak to this a bit?
I don't know all that much about that particular issue. Maybe Franklin's a little closer to it, given his work in his previous role for Naxos. But the one issue that I thought was there's a few interesting issues under the proposed act, which, by the way, passed the House 415 to nothing. So a very rare fit of bipartisanship, which is kind of surprising. But I guess music can bring even politicians together. But one of the provisions that's interesting, at least that caught my attention, is that now there's an ability for sound engineers and remixers and other folks that are involved in the audio production of a particular piece to ultimately get some portion of a payment or a royalty stream from in some form or fashion, which I thought was an interesting development. But Franklin, do you are you maybe a little bit closer to the pre-1972 sound recording issue that Denise was mentioning?
Right. Yeah. So essentially, prior to the 70s, the Federal Copyright Act did not recognize a ownership right or copyright protections for performances that were fixed in a tangible medium of expression, for lack of a better explanation. But so that was a big issue. So prior to that, and this also plays into why we've seen a lot of over the years, a lot of litigation stemming from state level issues, because prior to that, the 70s, it was basically state level laws that provided protection to copyrighted works that were fixed as a sound recording that was fixed. So a lot of times that was seen under anti-piracy statutes and in efforts to curb illegal copying of tapes or records and that kind of stuff. So that's like a really gross simplification of this area of the law and the history behind it. But what this new Classics Act provides is a way to finally recognize at a federal level these protections of pre-72 works in sound recordings. So does that kind of give a good overview? I mean, I can pull up a document that I can go much deeper into detail if you want. But
no,
I think this
is a topic where it's real easy to get into the weeds. I'm just wondering where you come down on this dispute. There's a piece in our discussion points arguing with Professor Mark Lemley, who tweeted out that this is a term extension, essentially makes a term extension for those pre-72 works for which royalties would not otherwise be available. And I think the point of the pushback on that is, well, no, they're still going to fall back. They're still going to fall out of copyright at the same time. They're just going to be eligible for royalties while they're in copyright that they wouldn't have otherwise been eligible for. Does that sound right?
And yeah, so that was an excellent rundown that Terry Hart over from the Copyright Alliance put up and posted in response to that. And that was an excellent synopsis, essentially, of that. And so, but going back to the Music Modernization Act as a whole is the three main parts. So the Classics Act that we're talking about is just one component of three major parts, which the first one being the Music Modernization Act, as it was prior to being combined with the Classics Act and the AMP Act. And the Classics Act stands for a mouthful, which is the Compensating Legacy Artist for Their Songs, Service, and Important Contributions to Society. And then the third one that it was combined with is the AMP Act, which is the Allocation for Music Producers. So yeah, it's a hefty piece of legislation, but luckily it is something that is, it has a lot of bipartisan support and is moving quickly through the necessary steps to update this really antiquated piece of law. But
is your take that it's going to be good for huge streaming services, and it's going to be good? Well, do you think it's only going to be good for the huge streaming services? The Copyright Alliance likes it too, and they are an industry group. So, if they're both happy, who's not going to be happy about this?
Right. So I think that there is some, just in general, you're not going to please everybody. That just kind of happened. But one other area that's kind of gotten a lot of attention has been this the clearinghouse portion of it, the public performance blanket license clearinghouse that will be set up. So the bill will ultimately create what is being referred to as the Mechanical Licensing Collective, or MLC, and it would collect and distribute the mechanical royalties to copyright owners of the musical compositions. So that is a mouthful, but just to break it down simplistically, when it comes to music copyright, and I'm sure I actually know both of you are well aware of this, but for listeners that might not know, there are two elements of copyright protection within a song that you might be hearing on the radio or listening to on Spotify. So you have that actual sound recording, like that particular version of the song. And then you have a second copyright as well in the underlying musical composition. So the sheet music, the lyrics, all of that compositional aspect of the sound recording that's being heard. So those two distinctions are important when you're going into this MMA, the Music Modernization Act, because when it comes to the clearinghouse side of things, for going back to your original question about the tech companies being happy about this, the streaming services like Spotify and Apple Music and whatnot, they'll be happy because currently when they need to get permissions for the sound recordings, so if they want to go to Universal, Warner, or Sony, the three major labels, as well as all the other indie record labels, they can go and it's pretty clear most of the time to know who they can go to and get permissions for the sound recording for those particular versions of the works. But when it comes to the second aspect of copyright that they need to secure, it's the musical compositions, and that's where it gets a little sticky, and it's kind of never been simplistic. There's never been one centralized location where this blanket license can be obtained. So what the Music Licensing Collective does is it's established by this bill, these two bills, and it would allow for a single location for a Spotify or a Deezer, if anybody is over in Europe, to come and obtain all they would just go to a one-stop to this Music Licensing Collective and obtain all the rights that they need to be able to put this music on their platform that they've licensed from the sound recording owners. So that means if another example is if you're like a Pentatonics, which is if you're a cover band or something, that's a bad example because they have their own music now. But if you're a cover band, then you can license to Spotify through TuneCore or some other method. You can license your music for inclusion on a platform like Spotify and not necessarily have to worry about the underlying composition rights that Spotify would need to secure in order to stream your cover song. So the MLC...
Maybe I'm understanding how this is going to work incorrectly. Under this new regime, do you even have to license to Spotify anymore? Can't they just decide what they're going to play without having a license from you as the artist?
Right, and so that was one area that was attacked, I guess, if you will, for this collection, for this collective, this clearinghouse organization, is it requires registration with them to be able to secure the funds. And it's similar to what is currently happening with a company called Sound Exchange that some listeners might be familiar with. I'm sure both of you are familiar with it as well. Sound Exchange collects for internet radio. So whenever a sound recording is played on an internet radio station, they collect the royalties and pay it out from there. So it's essentially, that is a one-stop location that Pandora and any other webcasters can go and obtain, and they go and they report to Sound Exchange what they've been streaming for however long period of time based on their agreement, and they pay out. And then from there, the money is divided up and paid out to all the rights holders. If a particular rights holder can't be found or they haven't registered with Sound Exchange, then that money is held onto for a certain period of time or something like that. Similar stuff happens overseas in other countries outside of the US in terms of there are already singular collection societies, and they have what is, I guess, some people in the music industry would refer to as a black box of royalties that are unclaimed. And then from there, those after a certain period of time lapses, those might be distributed out to all the people that have registered because a certain time period lapses. So that going back to this mechanical licensing collective, this MLC, that is certainly the same issue that's being brought up. Is there's basically a requirement now that you have to register. If you're a songwriter, you have to register with this mechanical licensing collective, this MLC. You have to register with them to be able to get paid. And then that may or may not make some people happy or not. But in reality, in practicality, it does assist in creating a one-stop location where it's guaranteed that payments will ultimately, or more likely to be guaranteed, that payments will ultimately make it to the owners of the copyright.
Mm-hmm. Are royalties going up under this regime, streaming royalties, from what they are now, or are they just remaining constant?
Right. So one of the other aspects of the bill is that it creates a fair market rate for paying songwriters. So that is another benefit in that it will hopefully help increase and keep up with the times as inflation occurs, as other factors are considered. I'm obviously not on the finance side of that, but it will hopefully impact for the good.
So that's something that we'd have to be reassessed, I assume, periodically.
Right.
And then the other thing I'm wondering a couple of other things. I'm wondering if exclusives, like when Taylor Swift is only streaming her music on one service, or, name your artist, do we have an exclusive with TWiL for a certain amount of time before we're going to allow other services to stream the music? Will those kinds of things still be able to exist under this?
Well, so first of all, the good thing is that has, for the most part, gone away, with the exception of TWiL. So TWiL still, I think, has the exclusive streaming rights for the most recent Beyonce, or probably, I know for sure it's the most recent Beyonce. It can't be streamed on other platforms except for singles, maybe. But for the most part, the music industry has recognized that doing those windowing periods and exclusivity periods for when music is made available on a streaming platform versus when it's made available to purchase or made available to stream on one platform versus the other. That's thankfully, for the most part, gone away these days. But the windowing period necessarily has not, because Taylor Swift and Adele, the big name artists like that, will still wait a couple weeks after a record's released to put something available for streaming, either on a free tier or not. But essentially, so in this case, going to your question though, it would not eliminate the need for them to still obtain the permissions from the record owner, so the sound recording owner. So if you're Taylor Swift, who is signed to BMG, who is signed to Big Machine, an independent music company, then let's just assume that her record label owns all the rights to her music, her sound recordings. They would still, Spotify or Apple Music, or insert your name of your streaming service here, they would need to obtain the license to be able to stream that sound recording. Where this might assist them is if you have all those cover artists that are wanting to put up their own version of the new Taylor Swift song or Taylor Swift single. I apologize, I'm singling out Taylor Swift because she's the one that's most notorious for doing this. But I don't think that this would prevent them from being able to accept now more easily those cover songs and those cover versions, because it is they are able to get it now through legislation. They're able to get the compulsory license through this mechanical licensing collective.
All right. Phew. Interesting. One other question, and I'm sure Mike has questions too. Do you think that this makes it easier in any way to compete in the world of streaming music? If you want to go head to head with Spotify or Apple Music, that's not an easy thing to do. Does streamlining some of this mean that it now becomes easier?
I think from the liability standpoint of being able to start a streaming service and not have to worry as much about receiving these, like having to worry about receiving the complaints and the potential litigation actions against you from songwriter collectives or individual songwriters like we've seen in the past with Spotify. I think that it will assist future and maybe alleviate the need, help increase the ability for a music startup to happen. But again, I think that the other piece of the puzzle that's key is the fact that the sound recording side of things is still on a per owner basis. So
right.
They basically, to be if you want to have a more mainstream successful service, you would still need the licenses secured with the 3 major labels and the major, whether it's one of the major indie collectives or pursuing them yourself. I think that still remains the missing, the hardest aspect of somebody coming new to market with a streaming platform.
Got it. Mike, anything you want to chime in on?
I mean, just that, music copyright, it's such a game of inside baseball. It's so fiendishly complex. It's amazing to hear you talk about everything, Franklin, with all the various interests and all the different players that are involved. It's funny to think that, 110 years ago, I mean, this really all started as a result of player pianos. This whole issue didn't exist until, way back then. But it's interesting to think about the evolution of music and all of the various facets to it. It's a pretty fascinating area of the law.
Yeah, it sure is. All right, well, let's make good vibrations our first MCLE passphrase for this episode of This Week in Law. We put these phrases in case you are a lawyer or other professional who likes to watch or listen to our show to receive professional credit in your field. And if you are a lawyer in the United States, head on over to wiki.twit.tv, find our This Week in Law page there, and you will find a chart, I think, thoughtfully provided by one Franklin Graves, as a matter of fact, that will help you navigate how to apply for credit in your very own jurisdiction. Where should we go next? Well, we're already talking about music, so let's play that fabulous music bumper and keep talking about things in the music and entertainment arena. Let's talk about video games for a minute. First, let's talk about Lindsay Lohan, because why wouldn't we?
Why not?
I think we had mentioned on the show before, your blog, the TMCA, has been following it from the get-go, I think, Mike, that she had sued the makers of Grand Theft Auto, claiming that her image and likeness, I guess, not her name, were being used without her permission within the game Grand Theft Auto. She lost, and then she appealed, and then she lost again. Do I have that right?
You've got it right.
Yeah. So I think the crux of that is, even though a character may resemble you, unless you are distinctly identifiable as that character, you're not going to win your right of publicity claim. And I think that's what she's been able to show here. Anything you want to add, Mike?
Yeah, I think that's right. I do think this is an interesting case. I think it's I could conjure up a set of facts potentially, or some arguments that may have gotten her at least a little bit further down the road. I mean, she, the character in Grand Theft Auto was a character by the name of Lacey Jonas, identified in GTA as an actress / singer, voice of a generation, really famous, known to have starred in romantic comedies and in dance-off movies. So and then there were some images of her that she claimed were similar to some publicly available images of her. So you pull all that together, it still wasn't sufficient from the court's perspective to at least convince the court that they were trading in on her name, image, or likeness. But I suspect that if a consumer survey would have been done, the results might be different. People may have, combining the name Lacey Jonas with some of these other elements. You might have consumers that would think, oh, well, yeah, this is kind of a reference to, or kind of you're kind of riffing on Lindsay Lohan. So I don't know. It's an interesting case. It does go to show that you do have to. There's going to be a bit of play in the joints here with most courts when it comes to these sorts of issues. You got to be really thinking about the evidence you want to be able to line up in a mass to be able to prevail. And she just came short on this one.
Yeah. So you're saying that this is something she could have done. She could have presented evidence and expert testimony around the evidence that lay people looking at the game would have gone, oh, that's meant to invoke Lindsay Lohan. But she didn't do that.
Yeah. I mean, and she didn't call me about the case, so I didn't have the
That's too bad
to get my thoughts on it. But yes, it strikes me that there was at least something there. I could see why she initiated the complaint if she felt like it really was they were trading on her name, image, and likeness and personal attributes associated with her. But then again, I mean, I can also see from the court's perspective that, some of these are just kind of general ideas and concepts that you could apply it to a whole host of different folks. So,
sure,
it's a close case. I think the court, based on the evidence, at least that I saw, I think the court made the right decision. But good example of how, you can, you present facts in a slightly different way or a slightly different bit of evidence. It might have turned out differently.
Right. And there's nothing the Court of Appeal could have done if this evidence wasn't part of the trial, which it wasn't.
Correct.
Yeah.
But my colleague Ryan Meyer did a great write-up on the case at tmca.com. So I commend it to everybody.
Yes, I enjoyed it. All right. Well, since we're talking about Grand Theft Auto, let's move from its characters to its music. Franklin, this is fascinating that you caught this. Back to music licensing for a moment. That Grand Theft Auto incorporates, I'm not a big player of the game, nor do I know or people who are, so I haven't been that exposed to the fact that there are radio stations within the game that play in the cars. And they're radio stations with various themes. So I guess it's a thing in this game rather than just cranking your own music off your non-video game device of choice, there's music in the game that you can play along while you play. And these radio stations have to license their music I guess they have. I wonder, is it different because the radio station is part of a game, or would they be treated just like a radio station in the real world? Or I don't know, weigh in on that, Franklin. What do you think?
Right. So I think at the heart here, what we're looking at is a classic synchronization license or master use license. So a master use and synchronization license for a video game. So I want to kind of, if I can, take a moment to educate and talk about the key differences there.
Sure.
So a master use license. In the entertainment industry, you'll often hear people just refer to something called a sync license or a sync deal. And that is just one half of a larger puzzle that is music licensing for use in films, television, ads, video games, you name it, special projects. So essentially what you're looking at here is a video game that needed to obtain a license, a master use license. A master use license is kind of what the name implies. It is a license to use a master sound recording in some fashion in connection with a film, a video game, or whatever. So in this case, it would have been the in-game experience of having music played on a quote-unquote radio station in the car. The reason why I think your distinction is kind of funny also, it is a good question, though, because it's a radio station. but I think it's not a true radio station in the sense of a terrestrial radio station or a webcast station that somebody is actually playing DJ and controlling.
Right.
What essentially we have here, as I'm sure you're aware, is just simply a set of audio files that are baked into the video game, and then from there they just play on a loop over the radio station in the car. So that is essentially the master use license would be necessary for the sound recording in that sense. But as I said earlier, with copyright, those of you listening, you still have to get another license for the songwriters, for the composition owner, essentially. And so in that case, that is technically the synchronization license, which is syncing that together with the visuals that you see. So with Grand Theft Auto, in this case, they had these licenses secured for Grand Theft Auto 4. And yeah, I have not played these games since I was in college, so it's been a while. But they are very graphic and violent. But I guess if you want to jam along to music while you beat an old lady with a bat, you certainly can in the game. So regardless of all that, so essentially about 10 years now since that game came out. So Rockstar, the developer of that game, needed to take care of the fact that they, I guess, originally only obtained a 10-year license for those sound recordings and the underlying composition to be included in the game. So at this point now, back in April, the end of April, those licenses expired, and they either were able to renew and extend and obtain another license, or they simply, as the article talks about, they replaced it with different songs. So they were able to license either probably more likely on a cheaper basis or on a hopefully in perpetuity basis, because the last thing they want is to have to go back and do the same charade again in another 10 or 20 years. So as we're seeing, and I think this will be part of a larger discussion we could have, but video games are living much longer than they used to back in the era of cartridge or console only games, where they're now being brought back to life in an official capacity on newer systems, simply because the technology is there to easily port them over and upgrade them for the newer systems.
Right. So you raised the issue of whether there's some sort of societal interest in preserving the game in its original form with its original looping music on its original radio stations. We've talked about the MADE Museum in Oakland, California before, the Museum of Art and Digital Entertainment that aims to preserve digital art like original video games in their fully playable state. So I'm sure they would have something to say on that front. But it seems like maybe it just was bad foresight to only negotiate a 10-year license or not renew the 10-year license. How would you have handled this, do you think?
Right. Well, I certainly don't want to discredit the attorneys or people that were working on these licenses and securing them originally. I guess I shouldn't say attorneys, because in the entertainment industry, there are often non-attorneys that are securing licenses in licensing clearance houses or whatever licensing departments of companies. But I certainly don't fault them, because you never know or understand the circumstances, especially. Maybe this applies to Grand Theft Auto if we're talking about the fourth iteration of a successful game franchise, but there still are costs involved and a need to keep costs down. So one of the most common ways to get costs down is by negotiating cheaper licenses, which in turn would be a shorter term on the license or more limited use of the license. So they could have also not had a license to re-release this game on a different format. Sometimes they might be so specific to be written in a way that it is only allowed to be on Xbox 360 or PC consoles, which I guess could be, that would be pretty broad. But either way, I think that's another important distinguishing issue there. So regardless, I think that there are other options. So in this case, one of the common ways to get around this is, if you don't have the budget up front, you can always go ahead and at that same time, while you have all the parties at the table together, go ahead and negotiate options for additional terms to be added. They're already included in the agreement at a set price at that time. And again, that way, if you come up on the 10-year renewal period or the 10-year termination period, you have the option to go into those renewal periods as well that are already negotiated, and you just have your accounting department send out the check and you're good to go for the next 10 years or whatever.
Right.
But yeah, I think that is something that is very important for indie game developers or any kind of game developer or any content creator really, is to understand the scope of the license that you are obtaining when you're creating a piece of content or a work that you're creating. You want to make sure that you have the ability to not have to go back and do an alternate cut of a film or a TV show. And I think a lot of TV shows actually that are on Netflix now fall prey to the same issue, because back when they were first back when they were first created and the music licenses were getting obtained for an original broadcast airing, they might have only secured the rights to a VHS or a home video use after that. And so now that we have streaming platforms, those aren't covered in those licenses. So that's why you might sometimes hear different music in like Dawson's Creek or Friends or something like that.
I've never noticed that before, but that's a hilarious artifact of what we're discussing. It's not just the license that you're securing as a creator. I think you have to pay attention to the one that you're granting, because as this Kotaku piece in our rundown points out, there are people who are seriously miffed that they're not getting their original looping music from their radio station in this game, and they are, working as people do on workarounds to try and escape the updates and make the game play in its original format. And I would think they might have an argument, depending on the scope of that license, that Rockstar is in breach of the license that it granted. That, you promised us this game. I own this game. This game is no longer available to me. So I may rattle your legal cage, Rockstar. I don't really think people would do that. I think they would try and get a workaround, and if it worked, great. They'd feel good about the fact that they'd, figured out a technological fix to their bugaboo. But if someone really wanted to put it to Rockstar, they might claim that they were no longer being delivered what the license had told them they were getting. Now, most licenses are carefully worded not to permit an action like that, but you never know. That this is, as you point out, Franklin, this was probably not in anybody's mind when the game was developed.
Right, exactly. And I think the key that you just used there, the key term, is license, because as we've seen, especially in the digital music age as well, like when you quote unquote purchase the song from iTunes, you're not actually purchasing it. You're purchasing a license to a limited use of whatever that piece of content is. So yes, I don't have a way to go back and look at the original license or terms of or EULA or terms of service that might have been included with GTA 4. But if we look at the current Rockstar games, if we look at their current terms of service and their current EULA, then it does include language that allows them to modify or further update, patch the games as necessary. So that would easily include this opportunity to remove music that or any other piece of content really that may or may not be subject to a license that has expired in some capacity. So.
Right.
Yeah, but, I think that one of the other points I brought up in our discussion notes is the newer games that we're seeing now. I don't know. Do any of your kids play Fortnite or?
Oh yeah.
I have a 14-year-old. What do you think? I live, breathe. I don't play the game, and I live, breathe, wake, sleep, Fortnite.
Right.
The question, Franklin, is. The question is whether they're ever not playing Fortnite.
Exactly.
Yeah. That's a better question. When are your kids not playing that game? But I think that's another interesting issue there is with these games in particular, they're set up in a style of what are referred to as seasons, where you go through different seasons of the game. And so just like a television season, after a certain amount of time, that season ends, and then the developer chooses to launch another season that either progresses the storyline or offers some other additional changes to the game that we're building upon the last. And so each month, or each time a season is released, in the case of Fortnite, you have the option to pay. It's completely free to play. First of all, we should mention that there's no reason you have to actually buy anything if you just want to play the game and not experience any of the other fun types of outfits you can put on your character if you want to be John Wick, which is a very popular one all over the internet at this point. But regardless, you don't have to pay, but you do have the option to pay what is essentially equates to $10 worth of in-game credits to purchase that season and get additional benefits such as faster level progression, to get additional bonuses, that kind of thing. But you're not buying the game. You're buying access, a license to access that season and the additional in-game paid content for that particular season. And after that, you understand that, or most kids these days understand that they're not going to be able to do like what I can do in my generation. Like even here in our office, we have a Nintendo 64 that you can go and still play now, probably 20 years later? Has it been 20 years since that? Yeah, 20 years later, you can still plug in the cartridge and play Mario Kart and have fun. But 10, 20 years, even a year from now, would you be able to go back to what is now, like in the case of Fortnite, Season 4, and play this game as it currently stands? That is something that, it again, goes back to that issue of preserving this historical aspect of it and whatnot. But yeah, I think all those are very interesting questions that my mind just immediately started getting flooded with when I saw one of my people I follow on Twitter about this article about GTA 4.
Yeah, and I guess the answer to that question is Fortnite will recognize that there is a ton of nostalgia around video games, and people still will go buy that, huge arcade version of Centipede and put it in their home to be able to play and have that original experience that they recall from their childhood. So I guess the game manufacturers, they're no dummies. They'll re-release, play the vintage edition of the game. You'll have to pay for it and stuff again. But I don't see that going away. What do you think, Mike?
Yeah, I think that's. I think you're exactly right. That makes sense to me.
My favorite tweet of the last couple of weeks was by Stacy Solomon, who tweeted as follows: "My eldest, can I download Fortnite? Me, no. Eldest, all my friends have it and play, and I'm the only one who can't play. Me, let me play it and see. Zach goes to bed." And then she says, "I'm now 2 hours in, dressed as some kind of raven, on my way to Tilted Towers with 3 people I don't know." Just love that saga. Moms whose kids Fortnite. All right. What else? Let's talk about Poppy and Mars Argo, shall we? This is fascinating. Completely news to me, Franklin. So tell us who these people are.
Right. So I think that you have to kind of experience it. There's really no way to describe these internet personalities, these internet persona, as they are called, of Poppy in particular. But yeah, so it's very interesting, and I encourage anybody listening or watching the show to go and search into YouTube Poppy or Mars Argo. But it's a very interesting new style of entertainment that is very simplistic or very just interesting all around. So like I said, it's hard to describe, something you more have to experience, as I think all art is. It's best understood when you experience it yourself. So no judgment passed in that capacity. But what we're looking at here is what some are even calling as an offshoot of the Me Too movement in the YouTube space, is somebody who is suing, and that person, so I guess the three people that are involved in this particular issue, this lawsuit, are Mars Argo, who's also known as Brittany Sheets. And there's Mars Argo right there that you see on the screen if you're watching, not listening to the audio version of the podcast. But she is an internet personality, as well as a musician, just an all-around entertainer on the platform. And the other person involved is Titanic Sinclair, aka Corey Mixter. And then the third person that is important as well is Poppy, the person that I just mentioned, the woman that I just mentioned. That is Poppy right there. Like I said, very simplistic style of video, and sometimes very repetitive, sometimes just completely random. And I guess, yeah.
I could only watch so much of that, Franklin.
Sorry, what? Go ahead.
I could only watch so much of that.
Right. And she actually has a full album out as well that you can stream or go listen to somewhere on your favorite platform. But so essentially, Mars Argo, I don't want to dive too deep into the other aspects of this, because what's really interesting here is the copyright aspect to it. But there are a lot of other allegations going on in terms of abuse and stalking and all of the horrible aspects of what's been going on in these people's lives. And that's certainly not something that should be downplayed in any capacity. But to get to the heart of the matter that's relevant to this show is that Mars Argo is bringing a lawsuit against Titanic Sinclair, aka Corey Mixter, and also mentioned Poppy in the suit because she was maybe in a relationship at some point that went south, and Titanic Sinclair helped her create this persona, this interesting character on the internet, on YouTube, and their relationship went south. So then Titanic Sinclair moved on and allegedly recreated this persona and this interesting internet creation, Poppy. And around the same time, November 2014, around the same time that this relationship went sour that he was in previously. So of interesting note, Poppy also has a new YouTube Red show coming out. So she's been signed and is gaining a lot of popularity and name recognition, whereas most people might not be familiar with Mars Argo unless they happen to be her fan as well. So essentially what the copyright issues here is that Mars Argo is claiming that Titanic Sinclair left her and went and recreated everything about her, recreated the similarities, as she's saying, in the format and appearance of the Mars Argo and the Poppy videos. The suit also is claiming that Mixter copied Mars Argo's identity, likeness, expression of ideas, sound, and style, and more. They even mentioned hair dyeing, because Poppy has an iconic platinum blonde hair that we saw in the video previously. So Mixter has basically claimed to have invented Mars Argo as well. So there's a lot of harassment going on there. But so this lawsuit's been filed, so it'll be interesting to see how that progresses. But actually, just a few days ago, Poppy came forth. Initially, neither one of them responded, Poppy nor Titanic Sinclair. And Poppy has now responded and called it, quote, a desperate grab for fame, and reveals painfully that she also has a history of dealing with abuse and domestic abuse of some kind. And so, so I think it's just a messy issue here. But what's really interesting is how this is going to proceed in terms of whether or not their claims of copying and ripping off of this persona that Argo created, how that will proceed forward.
The guy, Mr. Mixter, claims to have created a character, and that these women are both playing that character, and that their ergo Mars Argo has nothing to talk about. A little bit different than Lindsay Lohan's arguments vis-a-vis Grand Theft Auto, where she is the owner of her own name, image, and likeness, that And maybe that's what Marzago will contend, that no, you didn't create this character, I did, and it's me. And now you're capitalizing on it. So maybe she needs to call you, Mike. Maybe we need a consumer survey about the confusion.
Yeah, it's interesting. When it comes to characters, and I don't purport to understand exactly what the nature of the copyright claim is here, but it sounds like it's essentially, as you point out, Denise, that one character is a copy of another in some form or fashion. And, there's a fairly decent, robust area of the law that's been developed, including out of the Ninth Circuit, dealing with copyright protection for individual characters that appear like in films, for example. So it is possible that you could be liable for infringement of a particular character from a grander work or larger film. So again, don't know if that's a viable or particularly appropriate here, but it strikes me just on the surface that they may want to or going to draw on that series or those series of cases dealing with character protection and copyright infringement.
All right. Thanks for bringing that to our attention, Franklin. Last story in our realm of music and entertainment is just this dispute from this week about TWiL, on the one hand, who we've already mentioned, and I believe it's a Norwegian newspaper called Dagens Næringsliv. I looked that up. And this newspaper came into possession of some hard drives belonging to TWiL, and did some analysis and had a university do some analysis, and have come to the conclusion that TWiL is wildly inflating streaming numbers for both, who was it? Kanye West and Beyonce. And TWiL pushes back and says, no, this newspaper's out to get us. It's not the first time they've come after us and said bad things about us, and this isn't true. But this whole, just raising the issue of whether a company did or would manipulate the streaming numbers, I think is fascinating and sort of a sign of our times, because obviously if this did happen, it's to the detriment of lots of other artists. In this Business Insider piece that we have, it's talking about some of the journalism that the newspaper did, and that they went to, for example, they went and tried to validate, they could tell, which user was supposedly reflected in the streaming numbers in this data. So they actually sought out some of those users, such as a US-based law student named T.R. Fatia, who supposedly played tracks from Beyonce's Lemonade 180 times within 24 hours. And she told the newspaper, that can't be right. Either that, or she's just wildly embarrassed. So I just interesting development, and wonder what you think, Franklin. Is it the first time you've heard a streaming company be accused of this kind of thing?
Right. I think this is the first time we've heard of an actual platform itself doing manipulation of the numbers, but also this is one of the platforms in which it was basically founded as an artist it was actually promoted and originally promoted and founded as an artist funded and founded platform. So I guess it kind of plays into that whole mentality of, is there an incentive for these allegations of these actions to be happening or not? So go back to your question, is this the first time we've heard this? So outside of the platform side, we've had cases of not litigation cases, but just instances where bands would upload a silent album and call it Sleeper and encourage their fans to go and listen to it on repeat as they slept at night. And that way they would earn a lot of royalties from the plays happening. I guess I should use quotes there, air quotes there, for a lot of royalties. And
for plays.
And for plays, yes. So depending on what, can you be playing and listening to music while you sleep? It's a great question. But no, so that's mostly on the artist side that we've seen attempted manipulation of a music platform. I obviously think it's important to mention that the response from TWiL to Variety in this case, in this instance, they're calling it a smear campaign and have reason to believe that it's tied to other malintentions from this publication, and they have a reason to be acting this way towards them. But it does beg the question, especially in the day and age of Spotify going public and in other platforms like that, what ability do they have to control and manipulate how music royalties are paid out when they're the ones controlling and overseeing how the reports are generated and the calculations are made and what is considered a play and all of that. So I think it is very interesting, but I like to have some type of belief in the company for hopefully not behaving in this way. So
hopefully, yeah. Go ahead, Mike.
Oh, no, I wasn't going to say anything. Very interesting story, though, Franklin. Thanks for bringing it to our attention.
I think
that one was me.
Oh, it was you, Denise. Yeah.
Yes.
But it does beg the question of if you install a music platform, their application on your desktop computer, could they put something in the terms of service that allow them to, in some ways, impact how your account is used without your permission in the background? So if you just have it running and you're not actually listening to anything, is there a way that they can have it where something else starts playing or is muted and starts playing or something like that? I think that's another interesting question. So, yeah.
Right. Yeah. I mean, all of this is sort of smacking of mining Bitcoins or mining, using otherwise idle computer cycles to generate revenue for someone. Maybe you could mine music royalties this way. Interesting idea. Let's move on and talk about a couple more trademark issues. It's funny, we do a podcast and have done for years, and we do a podcast about technology law, but we don't get to talk about podcasting law that much. And now we have some in the trademark arena. Interesting, and I'm not sure I agree with the outcome here, Mike, that was written up by Farah Sunderji. Am I saying her name right?
Sunderji, yes.
Sunderji, one of your colleagues at Dorsey and co-author of the TMCA blog. This is a question of whether the very famous, well-known, wildly successful This American Life podcast called TWiL can trademark its name. And the TTAB has said no, right?
That's right. By and large, I think there were 4 different applications that were submitted, and 2 or 3, I think the examiner and then the board ultimately rejected as being generic, not protectable.
Right. And this is another situation where it seems like we need one of those public opinion surveys.
You got it.
Consumer surveys.
Right. When Farah was after she'd written about the case, we were commenting to each other about how this should have been a winnable case from our perspective, because if you the consumers at issue are consumers that listen to podcasts, and if you listen to podcasts, if there's one that besides your podcast here, Denise, you certainly know TWiL, right? Mm-hmm. I mean, that's very, very well known. Mm-hmm. And people in the trade, people in the know, I think would say, of course, TWiL is a particular type of podcast coming from a particular source. But it didn't look like they developed that type of evidence that would allow the examiner and ultimately the board to reach that same conclusion. So, I mean, the analysis I think that the board did is sound based on the evidence. But I think, as a marketplace reality, I think that this is a a poor decision in that it should have been registrable. It's a mark that I think is a trademark, and it should be protected.
Right, and that's because the podcast itself has brought distinctiveness to that term that would otherwise be a generic term.
Right.
Yeah. All right, we both agree, but the TTAP doesn't agree with us. So
yeah, and I probably would have come out the same way were I the decision maker at the TTAB, just based on what the evidence was. As a judge at the TTAB, you're kind of confined to considering the record evidence. Right. You can't really go outside of the record, and even if you know personally or have reason to believe that consumers in the know do in fact would have good familiarity with the serial name, it's not really something that can be considered by the judge. So,
right,
unfortunate.
Yeah, it is. It seems like not the right outcome. I don't know if this is the right outcome. Yeah.
Once again, Sarah Koenig, she should have called me.
Exactly. Definitely. Maybe next time. Right. We'll hold out hope, Mike. Maybe Beyonce should have called you as well, but I think we've talked about this before, and the outcome here remains the same as what we've discussed before, that when Beyonce and those who work with her thought it would be a good idea to try and apply for a trademark in Blue Ivy Carter, the name of her daughter, that they really should have had some sort of product or service associated with that mark in order to have it withstand scrutiny, right?
Well, I think that's generally correct. The application, as we've talked about before, and I think there were two, right? She submitted one for Blue Ivy and then for the other kid, and I think she's had this history, as I recall, of trying to lock down trademarks with respect to any number of goods and services. And the one for Blue Ivy here, there's some baby related products which certainly make sense: baby teething rings, baby carriages, baby strollers. You could see how that would probably be used, or that they would have a good faith intent to use this particular name on those goods. But I mean, then we get pretty far afield here and start talking about playing cards and golf balls and tennis balls, all of which she attempted to register. Now she indicated to the PTO that, look, I'm registering this under 1B, which what that means is I have a good faith intent, a bona fide intent to use this particular mark on these particular goods. But I mean, this is, there were 14 different classes or something like that, with, varying from, as I mentioned, from baby-related products to hair oils to tablet PCs to cellular phones, golf balls, racquetballs, all sorts of stuff. So yes, you got to maybe be a little bit more strategic in what you're attempting to register.
Right. Franklin, any thoughts before we move on?
Right. I thought it was interesting in this particular case of Beyonce and her holding company was that it was the opposition that occurred from the company Blue Ivy. Is an event planning firm. They were the ones that brought this to light and were going against it, trying to say that there is no real intent to use here. So I thought that was interesting. But Mike, I'd be interested to hear your thoughts on how, because I know in the entertainment realm, a lot of celebrities or well-known personalities are interested in protecting their names and the names of their offspring for any potential future use they might have or see, or just to simply prevent others from marketing products that are based on or play off of that child or the entertainer's name. So without running afoul of the true intent to use filing option and hopefully not permitting fraud, are there any other ways in which these types of protections can be obtained that you're aware of? Sorry for putting you on the spot.
You mean in terms of trademark protection or under some
Correct.
other regime?
Well,
Yeah, I mean,
trademark work is another regime that you're aware of.
Yeah, I mean, I think it certainly is a common practice and has been for the last several years with celebrities and other famous athletes and other folks to try to lock up phrases. Taylor Swift, for example, is pretty well known for doing that. Where before one of her last albums, I believe it was 1989, she had filed on the eve of or close to the date when the album was released, a number of the lyrics from that particular album had applied for trademark protection with respect to, 20 some odd different lyrics that were contained within the album. So anticipating, I would say that, I don't know which one of these lyrics is going to be huge. I know one of them is, and I want to be able to lock up that particular phrase and kind of take it outside of the public lexicon and try to trademark it and stop others from using it. So it's certainly a common practice. And, it's as our Lanham Act is currently formulated, I think it's a practice that by and large celebrities and famous athletes and others are able to take advantage of. You just have to be able to show that you have a good faith intent to use a particular mark. It's very subjective. It's ultimately hard to establish that you filed a fraudulent application. So, I mean, there's really no downside to doing it. A lot of times people will kind of pare things down as they go through the process, but at least kind of start with bulk and then shape a little bit is how this seems to be done.
All right.
Great.
Well, I think we're going to move on to talk about some issues in the realm of the Internet of Things, as Google I/O has been going on recently, and a couple of things caught my eye there. And we've had a lot of coverage of Google I/O here at the network, and I always like to watch and see what Google is unleashing on the world that might give us interesting things to talk about. I think last year it was its Google Clips camera. Maybe it was even longer ago than that. That thing is the AI camera that is small and unobtrusive and motion operated and is supposed to learn over time. And it has not really, I think, taken off, and B, been as controversial as we thought it might be. It's still for sale, and they seem to have dropped the price down to $200 from $300. So that gave us some things to think about and talk about. But this year, it's not the camera, but the assistant that I found really interesting, the one that sounds like a human. And the one that if you weren't aware that you were talking to an AI voice, or I don't even know if applying AI to this technology is appropriate, but it's not a human voice. You might not know that that's who you were speaking with. And that is really the issue is as these things move forward, will companies have at first an ethical duty and then ultimately a legal duty to disclose when the thing that you're interacting with is not a human thing? I think that the answer to that question is yes. I think that we'll all want to know whether we're talking to a particularly convincing AI or an actual person. And I also think that the opportunity to use this kind of technology for ill is quite high. I mean, telemarketing comes to mind, election manipulation comes to mind. Mm-hmm. So yes, I think that this is something our regulators will want to pay attention to, that even if Google has various safeguards in place, other companies with similar technologies may not be as scrupulous. Any thoughts, Mike?
I was thinking the exact same thing, particularly with respect to election manipulation. I mean, it would be, you could see it would be totally easy to set one of these AI off and running, and they just do a series of robocalls and all sorts of potential manipulation. So yes, I agree with you that it seems like this is an area that's going to be ripe for some sort of regulation sooner rather than later.
Right. Franklin, you agree?
Yeah, I definitely, my mind, I think any attorney's mind would be going along these same lines. I was moving away from more so the ethical implications of it. That article does a great job of surveying that. But I also am curious as to whether there should be some obligation that if this service is being used, especially in the way that they were in the demos, such as calling a hair salon or calling a restaurant to make reservations, whether there should be some opt-in opportunity for the person that is receiving this assistant duplex call from Google, because that information is being gathered and being utilized the same way that it would be if you were using Google to search or using Google Apps in some other capacity. So what agreement is in place, or terms of service, or terms of use, or interaction? That's an interesting question, I think, for the future. And I guess the argument could be that most businesses probably already have agreed to some type of Google agreement of some kind, whether it's whether they claim their business listing on Google Maps or some other fashion. But for those that maybe haven't, or some other uses, that's where my mind initially went to, was whether we needed something along those lines of, if I'm not the person that's calling in to, say, a customer support number to receive some type of help for something that I know I'm calling a company for, but instead this is the exact opposite, where that is an outbound call going to somebody that's not expecting it and has no reason to believe that they are then going to be having their information and the information they supply as part of the Google data set as a whole. So that's just one interesting aspect, and maybe that doesn't even need to be a consideration, because it's part of answering a phone call. You choose what to disclose when you answer the phone call. But I just thought that was interesting.
You don't choose to be recorded, though, and we have a lot of two-party consent states in the United States that would, I very much assume that that this couldn't function if it weren't being recorded and monitored and constantly tweaked. And so, being in California, which is a two-party consent state, you would think that Google would have thought through that one, that you've got to disclose at least that the call is being recorded. And that would be weird if you're calling and making a hair salon appointment or a restaurant reservation, right? Hi, I'd like to get my hair cut and I'm recording this call. It's just, a little bit beyond our realm of social mores. So something for them to work through on that front. And yeah, I think we'll see regulation around realistic bots who can call and do things for you. The other thing that regulation around might be in order for, you guys might have seen this article in the New York Times this week, that there have been researchers in China and the United States, here in Berkeley in California, who have shown that you can hide commands in different audio signals. For example, white noise played over loudspeakers, also YouTube videos. And in those subliminal commands hidden in the other noise are signals detectable by smart assistants that can get them to do things. So think your phone and its built-in assistant, whatever that may be. Think the devices in your house. They've been able to get them to turn on airplane mode, open a website, add something to a shopping list, etc. And it's nothing that you can hear or detect. So, as long as we're talking creepy manipulation by foreign powers, let's throw this one into the mix too.
Creepy.
And yeah, creepy. So the New York Times piece points out that they're There are no flat out laws against broadcasting subliminal messages to humans, let alone to machines. The FCC discourages the practice as counter to the public interest, and the television code of the NAB bans transmitting messages below the threshold of normal awareness. But we're not talking about TV here, so something else interesting to pay attention to. Any thoughts, Franklin?
Wow.
No, not immediately on this, other than you now probably need a new bumper that is just creepy. Just comes across as creepy.
The creepy bumper. The creepy bumper. Yes, please. Another birthday gift on your birthday from you to me. Mike, anything else?
No, not from my perspective. I've actually got to run. I've got a 1 o'clock call that I've got to jump on. But I just wanted to say, Franklin, again, happy birthday. Thanks so much for being with us. That was really great, and great to see you.
Thanks, Mike. Goes the same way. It was great to talk with you and throw a question your way and kind of get the answer I was looking for. So that's awesome.
Likewise.
Mike, great to see you. Thank you so much for being with us.
Thanks all. Take care. Have a great weekend.
We are close to concluding the show, but we have just a bit left. If you can stick with me, Franklin, and bring this one in.
Sure, let's take it home.
All right, great. So let's move on. Just a couple of things to note on the legislation and regulation front. One thing to pay attention to that happened this week is the Senate filed documentation where they're going to force a vote to disapprove the Congressional Review Act measure that undid net neutrality. That was a lot of double negatives in that sentence. I would be more excited about this, and you all should be more excited about this if it actually meant anything. But in my estimation, it does not. What it means is for politicians to line themselves up and self-identify on the net neutrality issue before the upcoming midterms, which is probably important. But it's not going to do anything to undo Ajit Pai's undoing. Here I go again. So many negatives of net neutrality. This statement by the senators is a good thing, and allows people to say where they come out on net neutrality, brings visibility to the issue. But even were they to succeed and enact their own Congressional Review Act measure that says, hey, we're going to undo the other one, it still needs to be signed into law by the president. And this president has indicated that he is all for Ajit Pai's strategy and program here. So it's sort of a hollow gesture, but the gesture was made. And one thing it will allow you to do is see where your senators are on the net neutrality issue, and continue to bring visibility to it before people have to be reelected in the fall. So any thoughts there, Franklin?
This is one area that I will happily bow out of. I have no comments to add to that.
Yeah, no, it's certainly important when we consider how much of the entertainment we discussed today on the show involves great big old pipes on the internet to get to you, and how it can, and whether it can, and what you have to pay for it, and who is pushing it to you all matters. And just the footnote to this is that the current net neutrality rules, which have remained in effect but are being dismantled, the finality of that will be June 11th, next month. So that is when the old open internet rules go away and the new rules go into place. And the FCC says the internet wasn't broken before this, and we're not breaking it now. But they certainly are undoing the open internet rules that codified net neutrality. So again, something to pay attention to, and we'll see what happens after June 11th. Again, we've said on the show, and I continue to believe, I don't think we'll see a whole lot of rushing into the breach by the ISPs. I think they are very much in wait and see mode, and they understand where public opinion is blowing on this, and they don't want to adopt a bunch of business strategies that they're just going to have to undo. So I think that for the next couple of years, we'll see this issue continue to play out. But the next move on the chessboard comes June 11th, when the old rules go away. So with that, let's move on to our concluding material for the show. And of course, we have not neglected to bring you an animal selfie of the week. This particular one is a much loved example of the genre in two ways. Number one, it involves squirrels. Number two, it involves a squirrel making off with, I assume, a GoPro. This was just posted, I think, last week. I particularly like this one because we get to see, nice squirrel running footage.
It's a very nice point of view there.
Right? And then we get to see squirrel breathing. The heavy camera, the little guys. Oh, now we're up the tree. This video actually goes on for about 5 minutes, so we're not going to play the whole thing. But it's super cute and involves the squirrel both as subject and as cinematographer. So wonderful example of, as I said, the genre. Our tip and our resource of the week are kind of bound up together. We'll do the tip first. The tip would be, and all of this is about, oh goodness, his name is Mason Ramsey, also known as the kid who yodeled in Walmart. Our tip of the week is sing at Walmart, because look at the amazing things that have happened to Mason as a result. This looks like his original clip. So Mason lives in a very small town in Illinois and went to sing in Walmart because, as he told Ellen, it's the only store we've got. So it was the place where he knew he could get an audience. He said he'd done it like 50,000 times. And some passerby shopper at the beginning of April captured that clip. And if you've been on the internet since then, you know that the rest is history, that Mason has become the stuff of meme legend. So there's that aspect to what happened to him. But if that had been all that happened, it would just be a little sad. Mason had been the star of this clip of him covering the Hank Williams song Lovesick Blues. And then it became this incredible viral sensation. So I thought, as a resource, Franklin, you and I could sort of unpack the various legal issues around what has happened to Mason. But let me just sort of finish out what has happened to him since he was originally recorded and became the meme sensation that he did. Mason and his family, no slouches there, latched on to this internet fame and have ridden it for all it was worth. He has been given his own concert at, I believe, the Walmart where this all happened, if not one nearby then. He has performed at the Grand Ole Opry in fulfillment of a lifelong dream. He's been given money by Walmart toward his college education. He has performed, he has soloed on a live stage with Justin Bieber in the audience right in front of him at Coachella. And now he has his own single out. It is called Famous. And it debuted on the Billboard Hot 100 chart at number 62. And if you haven't listened to it yet, I encourage you to do so, because the little kid is talented. He's not yodeling here, though.
If I'm gonna be famous for something, I wanna be famous for loving you. If I'm gonna be known around the world, I wanna
I just, love this whole story, and it made me think about the fact that this show was 2 years old when Justin Bieber started covering songs on YouTube in 2008. So we watched that whole progression. He had his first album out in 2009. Mason here has his first single out less than a month after all of this happened to him. So things have ramped up in speed. And the other thing that was really interesting to me about all this is this time it was all about the remixes and the memes. That's really what spread the word about him. And remixed in so many different ways. There is a particular EDM remix that I just absolutely love. So he is just a phenomenon. And so from the musical legal standpoint, Franklin, what do you think about all this? First of all, we've got cover songs involved. We've got him covering Lovesick Blues in his inimitable style that kicked all this off. No legal issues there that the original poster to YouTube or YouTube itself would need to be worried about. Oh, there's
right, in that case, it would
version going here.
Oh yeah.
My favorite is actually the SoundCloud one in the rundown. Victor, if you want to spin that one for us. There's no video, it's just the audio. When you can.
Yeah, sorry, I'm looking for it.
Okay, it's third link down under this story. Anyway, so the cover song, what do you think, Franklin?
So there are a couple issues there, obviously. So when the video is posted to YouTube, YouTube luckily has a nice set of licenses that they've already obtained for the underlying publishing that might be included in a video. So if it's a video like this where somebody is singing a song that can somehow get caught by content ID as that particular songwriter's song, then it depends on whether or not YouTube has a license for that already. That's one of the benefits, I think, for internet creators of uploading videos, or anybody uploading a video to YouTube, is they have the capability of having a lot of licenses already in place that they've obtained.
Looks like Victor has our track queued. Let's play that for a sec. I mean, that bass, come on. All right, so let's talk about that legal issue. Suppose, and I'm not saying this is what's happened, that track was just uploaded to SoundCloud by somebody who did a remix. But suppose others like me thought it was amazing and wanted to make a commercial market for that track. Certainly, Mason Ramsey hasn't authorized that use and isn't benefiting from any revenue there. So what do you think, Franklin?
So backing up just a little bit. So that's just what I was talking about is if somebody just uploaded the video to YouTube and hopefully YouTube has the license to do that on that particular platform. Backing up to the point in which the video is being recorded, there could be an argument that a bootleg statute of some kind, whether it's a federal bootlegging statute or a state level protection that might be available based on where this was recorded in Harrisburg. So I don't know the particular laws of that state. But yeah, so I think that's the first major issue as to whether or not this would constitute a performance that somebody either did not or did have authorization to record in some capacity. And that would be up to the performer, which in this case would be Mason, as to whether that is okay with him. But it also goes to the fact of if he's not already recording it a lot of the bootleg statutes, those aside, typically an artist or somebody will record their performance themselves so that they can maintain a copyright in that live performance itself. So that just is a rabbit hole we can go down based on the performance itself, in addition to whether there's a license to be performing in Walmart, or whether there is a license to be on the property for filming. A lot of issues there as well.
Oh my God.
Pursue it.
That's a good one. Yeah.
The whole SoundCloud stuff. I love the fact that people can take anything and remix it and put it up on SoundCloud. I think that's one of the reasons I even use SoundCloud, is because sometimes I want to go and hear somebody else's take on a particular sound recording that has been made available. But so I think all of that hinges on whether or not Mason owns a copyright in that particular public performance that he did of the song, and arguably he doesn't at this point, from what we can tell. So that's why they were so quick to put out an official song that people could go and purchase and hopefully get him some revenues to save for college or save for whatever his future might entail.
Oh, this won't be, I don't know. It's hard to make these kinds of predictions, but I don't think this is the last we'll see of Mason Ramsey. He seems legitimately talented and determined. So good luck to him. Yeah, we've talked about rights of publicity a lot in this show. A lot of the memes that have made his original clip so famous. That one of the best ones had the clip of Prince Harry. It's been previously captioned when I forget the exact caption, but when you hear your jam in the club and he has to run out because he's being interviewed, and he's on his air base in England and his squadron is being called up, and so he literally rips off his microphone and runs away. That is coupled with the original clip of Mason Ramsey in the Walmart, and the two together are like peanut butter and chocolate, two great things that go great together. But no one went to Prince Harry and asked for permission to do that, nor Mason as to the clip of his music. So here we go. There he goes. He's off and running if you're watching the video. We've got commercial versus non-commercial uses of all this kind of stuff. We could do a whole show on Mason Ramsey and his yodeling in Walmart video, but we're doing this at the end of the show, so we'll have to restrain ourselves, Franklin. I think we'll go ahead and put our second passphrase in the show and make it Hank Sr. in honor of all of this.
There we go.
And anything else you want to add before we sign off and say goodbye to Mason?
No, I think, like you said, that could be an entire show in and of itself. But yeah, maybe at some point in the future when he's super famous and selling out stadium or arena tours, then we can revisit. Right.
There's some sort of beautiful synergy to the fact that he himself posted a selfie that he took at Coachella with Justin Bieber, who made a point of catching his live set. There's just, 10 years on, this is what that phenomenon looks like. And what will it look like in 2028? I wonder. We can continue on wondering through the weekend, because we're going to go ahead and say goodbye to you this afternoon, and hope you enjoyed the show. So glad that you've been able to join us. We record this show every Friday at 11 o'clock Pacific, 1800 UTC. I think it's 1900 UTC this time of year. And that's when you can join us live and join in with the IRC chat, which we love jumping in there with you guys while we do the show. But if you can't do that, don't worry. Just head on over to twit.tv/TWiL, and you can go back to our shows in 2008 and watch as we marveled at the rise of Justin Bieber and how YouTube made him famous, and how this platform that we thought was all about cat videos was maybe about, certainly never not going to be about cat videos, but about other things too. So that's all there for you, as well as information, suggestions about how you might want to enjoy the show, wherever, whenever, on whatever device you prefer. So we're just glad that you join us when you can, and that you do. And we are really glad when you get in touch with us between the shows as well. You can email me. I'm Denise@twit.tv. Mike is Mike@twit.tv, and Matt, who is not here with us this week, is Matt C@twit.tv. Hit us up on Twitter, on Facebook. All of those are great places to let us know what's on your mind, thoughts that you've had about what we've discussed this week or in other shows, guests you might want to suggest that we have on the shows, jokes or remixes of Mason Ramsey. Please send those our way, your very favorites, please. And we'll feature some more of them if we get some in between now and the next episode. Franklin, I just can't tell you how great it's been to visit with you here on your birthday weekend. Thank you so much for sparing the time.
Thank you so much for having me back. I've really enjoyed it. I've had a great time talking about a lot of really interesting things, and I will continue to be listening. I do want to say sorry to the chat room. I was having a little technical difficulty, I guess. It wouldn't let me get into it, so I apologize. I wasn't able to join in on that side of things, chatting away and seeing what kind of feedback we were getting live. But
that's too bad. But we'll see you in there on future shows. I love that you join us and chat while we record live. It's very fun.
Thanks again.
Thank you, and thank you all for joining us. We'll see you next time on This Week in Law. Take care.